I believe like some of our students are sharing an account together, watching it together. So I think I'll start from here. So welcome to today's webinar session. And as the climate and environmental crises transpire, causing numerous deaths and miseries across the world, citizens and climate activists are increasingly seeking legal means to intervene into government actions. In Korea, this year, a group of teenagers filed a lawsuit against government alleging its failure to protect their rights from the ongoing climate crises. In August, a 23-year-old law student from Melbourne, Australia, filed a lawsuit against the Australian government, alleging that it failed in a duty to disclose how climate change would impact the value of government bonds. While most climate lawsuits have focused on government's duty to reduce carbon emissions, this is a world first case which addresses climate change's material impact on sovereign risk and debt sustainability. To talk about these issues, joining us now from Melbourne are Kathleen O'Neill, the plaintiff of the case, and David Barden, lawyer at Equity Generation Lawyers. Hi.
Hi there, thank you so much for having us.
Hi.
How is the situation in Australia regarding COVID-19?
Okay. I'm just in Melbourne and we've just finished our lockdown just this week. We had restrictions easing, but we had a 5-kilometre radius that we could go to, and yeah, only go outside for, I think there was some time where it was only 1 hour outside for exercise, and yeah, we still can't have people over and only 10 people outside to meet. But it's a bit different where David is in Sydney, I think.
Okay, great. Could you give a quick introduction of yourself, both of you?
Yeah, so I'm Kathleen. I'm the plaintiff in this case, but I go by Katta. I'm 23 and I've just almost finished my law degree at La Trobe University. I'm very concerned about climate change. I grew up in an area that has lots of forest, and we've had 2 very major bushfires in my lifetime, and they're getting far worse, and it's really terrifying to me that climate change is going to make events like this become more common. Yeah, so it's really exciting to be part of the case. I think it's got a lot of attention, and I think it's an extremely important angle for the climate crisis at the moment. I think everyone needs to understand about the connection between investing and economies and the climate crisis. So yeah, happy to be here talking. It's exciting to have international attention as well.
And I'm David Barnden, principal lawyer at Equity Generation Lawyers. And please excuse my attire. Because of COVID, we are largely working from home. So I am probably less formal than lawyers ought to be.
Well, let's move on to Katta. As we all well know, there was a series of bushfires from December to January across the entire Australia, but mostly in New South Wales and Victoria. Unprecedented in terms of its might and damage, burning tens of millions of hectares and killing billions of animals. So how was it like to you, and how it affected the discourse of climate change in Australia in general?
Yeah, well, that was, so for me, that was the second major bushfire. We had another one called Black Saturday in 2009, and that was really close to my house, and I have friends whose family members died and who lost their homes, and it was really like traumatizing event. And the fires that happened this past summer, I think just brought a lot of that back up for people, and it was yeah, I guess I'm not sure if I heard that the smoke traveled all around the world, so maybe you saw it a little, but yeah, here the smoke was terrible. Yeah, it's like almost black skies, and it's just, yeah, very everybody's just on edge because they don't know if the fire will come to them really at any time, and they know that it's affecting other people that are nearby, and I think there was a connection made to climate change with these last fires, and I think it really did start making people think about how we can go forward in the future, and that we need to start doing a lot more. But yeah, then we had COVID-19, so I think that took everyone's attention away from climate change for the moment. But at the moment, COVID is seeming to ease up a little bit here, so we're getting people starting to talk about climate change again, which is what we really need, I think, at the moment. So yeah, very grateful that COVID-19 is not affecting us as much anymore in Melbourne.
Despite the damage it caused, it seems that the government's response to the crisis can be summarized by its inaction to it. Scott Morrison, the current Prime Minister, who famously in 2017 brought a lump of coal to Prime Minister Questions Time, touting its cleanness, basically refused to commit to climate action even after the bushfires. And in fact, many argue that the landscape of Australian politics is controlled by fossil fuel lobby, and that both sides of the aisle, with a different degree, are participating in kind of a climate denial. Talk about climate politics in Australia.
Maybe David can help me with this one, but climate politics in Australia is very disheartening. Our politicians aren't really making any genuine steps to do anything about climate change at the moment. And we have an economy that is very reliant on fossil fuels. And I think that the politicians it's very hard to make that change, and there's lots of big business that keeps them wanting to have fossil fuels in our economy, and it's yeah. How would you describe politicians?
I'd certainly agree with that, and I'd certainly agree with your summary of the situation. We're now seeing a transition from essentially coal to gas. There is huge bipartisan support amongst the two political parties for gas, and there is an interesting dynamic where you have a lot of discussion and even in state level around reducing, well, you have some discussion around reducing emissions, but especially when it comes to exports, Australians, we export the most gas in the world and the most coal. It's really off to the side, and it's facilitated by the allocation under the Paris Agreement for responsibility for emissions, and it's a major issue. And there's projections that if we keep going as we are, that's Australia, we can be responsible for 17% of the world's emissions, with respect to both our exported and domestic emissions. So look, it's a big problem. In the Australian psyche, it's potentially overstated the amount that we rely on exports and the sort of the taxes and royalties from them. But there has been successful campaigns by political parties to sort of back in support for those industries. It's concerning.
As you mentioned, the fossil fuel industry now seems to be mighty and insurmountable. Yet the reality is that their lifetime is literally about to end. Beginning with China's declaration of carbon neutrality by 2060 this year, many countries, including Korea and Japan, are enhancing their climate commitments, joining China to announce carbon neutrality. Incidentally, all of these East Asian countries happen to be major trading partners of Australia, most importantly, importing massive amount of coal and gas. So talk about the ramification of this change, the series of declaration of carbon neutrality to Australia.
It's really important. It's shifting the debate even with Joe Biden's election. We have seen increased pressure on Prime Minister Scott Morrison to do something simple and sign up to a net zero by 2050 commitment. And that's a first step, really. Like a 30-year target is aspirational, and really what is meaningful are the short-term targets in reducing those. It's for our trading partners, specifically, as you mentioned, China, Japan, and Korea, and you know, congratulations for you and your country starting to lead the way. That's important due to exports and exports of our coal and gas. So yeah, it will have a significant impact on us.
Thank you for your answer. While here in Korea, we are just beginning to pursue legal venues to tackle climate change. I think there have been many climate losses in Australia, and what's interesting for me, and I think it's important, is that it's not just the youth and the climate activists filing lawsuits, but the Aboriginal communities dedicating themselves to protecting nature based on their sovereignty. So David, talk about the trend or the history of climate losses in Australia.
Yeah, it is interesting. There have been many attempts on a project-by-project basis to incorporate climate change into government decision-making. And as a part of those attempts, or as part of those challenges, Indigenous people have pushed back against a lot of development, a lot of consent and a lot of agreements around use of traditional land. It does get complicated in terms of groups purporting to represent you know, Indigenous communities on a wholesale basis. But we now see a trend that shifts away from this project by project litigation, which is typically used in the context of what's called judicial review, and you're probably familiar with it, but in Australia at least, it usually, if there's an error of law when a decision is made, that question is sent back to the minister, and often the decision is remade. And so at best you may have a delay in a project, as well as law which says certain things like climate change should be considered. However, what we do see now is a focus on more systemic issues, economic issues, and Katta's case is the perfect example of that, where we're saying that climate change risks will impact the whole of the Australian economy to such an extent that people who lend money, you know, countries, central banks, investors, pension funds who lend money to Australia will potentially be impacted due to the price of those financial instruments, in part, as we talked about before, our reputation and our failure to implement effective policies.
Speaking of systemic issues and economic issues, now let us move on to your case. So Katta, how you ended up filing a lawsuit against the government as a young law student?
Oh, well, David actually came to give a guest lecture at my university, actually face to face. So it was about the financial risks of climate change, and I went and talked to him after class. And up until that point, I hadn't really thought about financial risks regarding climate change. So that was a real eye-opener to me. And I think that day I actually went home and changed my super fund to one that's more ethical, which is just a program that we've got in Australia to keep money for our retirement, but it ends up investing a lot in fossil fuels. So yeah, it really helped me that day, learning from David about how where we put our money and what we invest in can really impact the effects of climate change. So yeah, I kept in contact with David, and yeah, we ended up filing this case, and it's been pretty crazy. There's been lots of stuff happening, lots of media attention. Yeah, I think that's how I got here. yeah, looking forward to where it goes. I think could possibly have really big consequences. And yeah, as you're saying, there's these fossil fuel industries do have to end soon. So I think the government really needs to listen to what we're saying and yeah, start telling the truth about the risks of climate change.
I mean, I think it's not that's so hard to pay attention to these issues and study and then learn and study about climate change and legal issues. But I think it's another thing to actually fight a lawsuit, as a individual. What was behind your thoughts, like when you made a decision?
Yeah, and it is so different. I think this is a completely different view on like the law. Like it's very different to my studies being involved in this. It's very I'm learning so much just even through all the correspondence I have with David and everything that he says, and it's very I'm learning a lot. But I think I just thought it would be like I thought the case itself was really important, and I thought I want to use my law degree to make changes, and this is exactly the type of change that I would want to see made. I think law is really important in that way that it has the power to make real change. So yeah, that's sort of why I decided to be part of the case.
Yeah, so Katta and David, could you explain facts and issues of your case? Might be too stereotypical.
Well, certainly. So, I mean, in terms of the government bonds, Katta has bonds which mature in 2050. So we do have quite a long investment horizon. In terms of the other facts, I mean, we are each week further and further in debt. Australia owes probably in US dollars around 500 billion in debt to central banks and investors all around the world. The facts of the case also turn on how ratings agencies are thinking about climate change, because that's a really important indicator of material risk. There's a threshold issue in that we say climate change is a material risk to whether or not investors will buy, sell, or trade in bonds. That's not a sort of a quantitative analysis, like we're not putting a sort of percentage or dollar value on that risk. It's a qualitative analysis, and from the sovereign credit ratings agencies, we see a trend to incorporate climate risks in their valuations and in their credit ratings. And we also have the circumstances where Australia is really exposed to not physical risks, which we've seen in the bushfires, which Katta has spoken about, and they've cost the economy. I think one of the latest estimates is around 1.3 billion. The bushfires last summer. But we've also got transition risks, and they amplify with each day that our government or our economy does not change or does not go towards a transition to a low carbon economy, the greater the shocks will be and the greater the cost that is. So we have this perfect storm in Australia of a federal government, at least, who is really pushing back, and possibly and we think due to the influence of the fossil fuel lobby. And so what Katta has done is ask for disclosure of those risks, and so in doing so, the government will need to think whether or not its actions actually increase risk, and so a disclosure should should make the government think about whether or not its actions on a global scale will assist it in issuing bonds and give confidence to people to lend money to the country.
Yeah, it's not impossible to actually, or to try to analyze and to quantify those risks. For instance, like Bank of England, which has been one of the most progressive institutions on the issue of climate change and financial stability, published a report this year showing that their QE program, the asset purchase program, is compatible with the global warming by 3.5 degrees Celsius by 2100. And the report also showed how their possession of GLID, UK government bond, it implies carbon emissions through the carbon emissions of the general economy. Has the Australian financial system or tried to participate in this kind of efforts?
Yeah, I mean, our Reserve Bank, our central bank, is a member of the Network for Greening the Financial System, the collection of central banks throughout the world who are interested in aligning or making moves to align economy to a lower carbon economy. But what we see is quite a change, quite a difference in attitude between our central bank and between our executive arm of government. And so our central bank, like most, is independent. But it does have it sits on the Council of Financial Regulators in Australia, which also includes our pension fund regulator and our company regulator. And those three entities are very concerned about the impact that climate change will have on our economy. They are attempting to quantify it through various means, including around the impact of declining coal exports. But we're a long way from the Bank of England, and there's really no analysis on sort of the climate change pathways that align with our current economic trajectory. But when you do look at carbon sort of climate action tracker, we're doing very badly.
I have a specific question about your case. Let's say that I take government side or trying to defend government position. I might argue that, which might be very extreme, but as modern monetary theory suggests, that government bond yield is basically a policy variable, arguing that a sovereign currency issuer like Australia has no inherent default risk. I might also suggest to look at Bank of Japan, which has been doing the so-called yield curve control for decades, or look at the Federal Reserve or the European Central Bank, which have been doing the basically same thing through the series of infinite QE, quantitative easing this year. Thus, climate change is not a serious risk to sovereign debt or sovereign risk. Or I might argue, while I agree that the issue of climate change is important, it's simply impossible to analyze its effect on sovereign risk. On the one hand, climate change destroys productive capacity, like destroying capital, leading to higher inflation and higher yield of bond. But on the other hand, just like the COVID-19 is doing now, climate change might stymie consumption and investment, leading to deflation and higher demand for government bond and lower yield. It can go both ways, so therefore it's simply too complex to calculate. How would you respond to these kind of rebuttals?
That's a very sophisticated response, and one which the government has not embarked on that sort of analysis as yet in the case. We, just as an aside, we had a hearing yesterday about how the case will progress, and Commonwealth is fighting it on legal points, but not on the point of materiality of climate change risk. They may fight that later, and that may be a matter for expert reports, but it's interesting at the moment they're not even talking about that, and they haven't raised it as an issue. What I would say, I agree with you that you know, sovereign bonds are extremely complicated in terms of valuation, and there's many factors that go into it. With respect to quantitative QE, you know, we are considering embarking on that process here, and we have seen our central bank do essentially that, but for buying bonds on the secondary market, not sort of to buy them directly. We would point you to the comments by the Swedish central bank last year in November, when it sold out of Queensland and Western Australian state government bonds, and they sold out on two bases. They equated the high per capita emissions in each of those states with financial risk of climate change, and their analysis of Australian dollar investments and bonds found out that those two states had the highest per capita emissions, and so they divested from those on the basis of that analysis. It's interesting that Australia as a whole now has the highest per capita emissions of all of the Australian dollar denominated investments that the Swedish central bank has. So it is possible that if it tweaks that that policy, you know, it could sell out of the Australian government bonds. When that announcement came out, it appeared that there was also a sort of a qualitative analysis as well, which referred to Australia not being known for good climate work. And I think that also comes down to the reputational aspect of us or our country being problematic during international climate negotiations. And another thing that the central bank raised, which goes to default and the low risk of bonds, is that inflation is or can be and is by them considered to be a type of default. So if obviously in countries which can print their own currency in which they issue the bonds have, you know, it's theoretically impossible for them to default because they can just print money. But if they do print more and more, and investors consider that their holdings are essentially devalued by printing more money, they will consider that as a type of default. And again, if climate change does have major impacts on society and the economy, and as a result, we do need to embark on QE, which we see now with COVID, then look, absolutely, there's still substantial risks for bonds there.
What kind of, as we speak now, what kind of arguments has government suggested, or what kind of procedural points that government has suggested to object to the case?
Yeah, so legal points. There's a point about reliance, and so there's a point which they're arguing that Katta wasn't actually misled by the failure to disclose. There's another point on the class action and whether that is sort of in fact too broad, because what we argue is that the duty that the government owes is not just to people who own bonds, but it's to a class of people that might invest in bonds. So there's arguments around that. And so they're trying to strike it out on the basis, so quite technical legal bases, but you know, our view is, for example, the pleading that relates to misleading or deceptive conduct is under a particular piece of legislation, and there's a general right for anybody to bring a claim of misleading or deceptive conduct, whether or not they would have bought that particular financial product or may buy it in the future.
I'd like to move on to Katta's. So as a law student, has your experiences or has your studying helped prepare the case, or how was it like to be a plaintiff? Outside the things that we learn from textbooks.
Yeah, I think, yeah, it is very different than learning in uni. But I think understanding the language is been really important. One of my friends listened to the hearing with me the other day, and they, yeah, didn't really understand what was going on. I think that general awareness of just terminology and how people address each other in courts and things like that, that's been quite helpful to know. And I think just being in the space and being generally interested in laws, and yes, I think also it's been really interesting as it's the first case of its kind in the world. I think that's something to be really excited about. My university has asked me to be on their law site for people, new students coming in, and they're really happy to be part of something like this. So yeah, I think, personally in my studies, I sometimes find it difficult that law doesn't seem to progress with society as much as it could, and I think that this case is an example of law providing justice to society and the people, and yeah, it is very different to uni, but when David came to give a guest lecture, I was in a subject called climate law. So the university is starting to put in subjects like that. I'm not sure if you have any like that in your university, but yeah, it is starting to be talked about. So yeah, I hope maybe that this case would encourage even more subjects like that to be put into curriculums, and for climate law to be much more of a focus in the future, which I think it will have to be, because we're getting a lot more
Well, actually, our school has climate change law class, and our professor here teaches that class in our environmental law classes. Well, David, I'd like you to talk about other cases that you worked on. Recently, you represented Mark McVeigh's case against superannuation fund Rest, and you settled the case with a fund committed to disclose its full portfolio holdings, conduct climate scenario analysis, and advocate for the companies to comply with the goals of Paris Agreement. Talk about the case.
Well, funnily enough, that was the case which was the subject of the lecture that I gave at La Trobe University when Katta and I first met. So there's an interesting link there. It was the first case in Australia and in the world that struck at the fiduciary duties, or the duties of trustees when they are looking after other people's money. In Australia, we have a reasonably well-developed superannuation or pension fund system, and That's been formalised in law since 1993. So there's big buckets of money. In US dollars, it's well over $2 trillion US dollars, and so it's one of the largest chunks of sort of money globally. And the idea behind that case was, first of all, to recognise that climate change is a material financial risk to a universal investor, and that flowed on from some regulator comments that were made in early 2017, and as a result, we were suing on the basis that the trustee ought to have acted upon that realisation. And again, it's more of a qualitative analysis than a quantitative analysis. And when you have the regulator saying that it is a material risk, then we think that was enough to make funds do things. And so the outcome essentially looked at what was appropriate for a fund to do. And there is complexity in that question because there are a number of levers that the fund can pull to, in an attempt to not just identify risk, but also mitigate it. And so those aspects that you brought up before were sort of part of the suite of things that funds can do. You know, they can engage with their investee companies. They can set targets because, again, there's a realization that a high carbon footprint might equate to greater financial risk. They can also participate in lobbying government because the transition risks that government policies put on our economy are significant, and especially when these universal investors have large investments in our economy as a whole, which is, you know, there are large companies in the mining sector and the sort of utilities sector that really make our economy overexposed to climate change transition risks. So we thought we had a really good outcome. Obviously the headline outcome to have a net zero target by 2050 was impressive, but we think it was an excellent holistic outcome because you did see a lot of changes flow through the internal risk management framework of the fund, and we were really pleased.
Well, as you explained a little bit, and as your cases show, it's now widely accepted that climate change will cause the next financial crisis through materialization of both physical risk and transition risk. In 2015, Mark Carney, then governor of Bank of England, compared the risk posed by climate change to the famous term Minsky moment. And since then, a lot of works actually have been done. Financial Stability Board established TCFD, Task Force for Climate-Related Financial Disclosure, to provide disclosure guidelines, and central banks have been talking about these issues, establishing NGFS, as you mentioned. In fact, just 2 days ago, UK government announced that they would start issuing green GLID, like green UK government debt, dedicated to green projects, which would be the world's first case. It also said it would make mandatory to follow TCFD guidelines for all firms in the country starting from 2025. How do you think that will the issue of climate and finance be significant in coming years? And why should future lawyers and law students pay attention to it?
Yeah, look, I mean, if it's not already significant, then something's wrong. But as you mentioned, the quite high level commentary from Mark Carney, and then flowing through to the TCFD, and now that being implemented in the UK, and New Zealand were the first to commit to that by 2023. It's huge, and so Katta can probably speak to this in terms of the bonds case, but one of the things that the fires, the horrible bushfires that we experienced in Australia did was sort of crystallize this risk, or maybe put it quite at the front of mind of investors. And you had a situation in Sydney, at least, where you would be normally quite protected from the force of climate change and the physical impacts, where just day upon day there was smoke, there was ash falling out of the sky, and it really brought it home. And so insurers are now struggling in terms of payouts, and also in terms of predicting the sort of future premiums they need, and the resources that they need to, in terms of pools of investments to help cover payouts. It's not a fringe issue. We have, as I said, our Reserve Bank talking about it, our regulators talking about it, and it's not a case of activists trying to tell business that they should be more aware of it. It's certainly come a long way.
Thank you for your answer. These have been my prepared questions, and now we'll take questions freely from the audience. Like, anyone can join in and pose questions.
Okay, I have some questions. I think I missed some part in the beginning that I just moved the location. First of all, what might be the landmark case in terms of the climate change in Australia? I mean, if we had, for instance, the US, we have a Massachusetts versus EPA, which is more related to like a mitigation related litigation. And I was wondering if there was, in Australia, there is a similar sort of a litigation to push the government to set up a standard or laws, or is it more like related to like adaptation related questions, and how flourished are there these climate related litigations are ongoing?
Yeah, it's a really good question. I'm not sure if we've seen yet the definitive climate change case for Australia. We unfortunately have very few constitutional protections, and a lot of the sort of the common law requirements, which for example, the Our Children's Trust litigation has relied upon in the US, has simply been erased in Australia. I think the two cases I think about when I hear your question, there's a case which is commonly known as the Rocky Hill case, where there was a judgment last year which suggested a coal mine could be knocked back from approval because it was incompatible with the goals of the Paris Agreement. And the other case is one that we're running at the moment, which tries to establish that that ministers in the Australian government have a duty of care to younger people, to not expose them to the harms of climate change, and that when particular decisions are made, such as to approve coal mines or other new fossil fuel projects, the minister needs to comply with that duty, and we're saying that equates to a circumstance where the minister simply can't approve any new fossil fuel projects. Beyond that, it would be great to see more litigation in Australia, but but we've certainly had difficulty sort of approaching it from, like, for example, the agenda style case, which attacks the emissions targets under international agreements.
Are there any tort-based litigation, maybe against like companies like a Rio Tinto, you know, something like that?
No, not yet for climate change. The case I mentioned against the Environment Minister, which we're running, does include concepts of negligence in it, in terms of negligent decision making. But you know, if we do look to the top 20 carbon emitters, BHP is an ASX listed company which is in that group. And we haven't seen any of those sorts of tort claims for damages.
How does the Australian court apply this legal standing requirement or political question doctrine or something? This is quite, you know, strongly and rigidly applied in U.S. cases. So how is it the same degree of, you know, just a procedural requirement? If you don't actually fulfill this procedural requirement, the cases are thrown out, or do you have more like a liberal interpretation of standing in these questions?
Yeah, standing is often a problem. Broadly, it comes down to having a special interest in the proceeding, and you know, by virtue of Katta, for example, owning government bonds, we would say that's satisfied in her case. But also there are other provisions which have open standing provisions, such as claims for misleading or deceptive conduct. So we do get into problematic territory when there's general impacts on the population as a whole, and you know, we are representing the sort of 8 people under the age of 18, and they're purporting to represent a class of people all under the age of 18 for the fact that they are vulnerable, and that the minister has this duty to not approve coal mines. So we are starting to stretch the standing requirements, and we do see pushback from the government for doing that.
I'd like to make a question about, I don't know, it might be somewhat political, but the Prime Minister, Scott Morrison, and he just after the news of Joe Biden being elected, he said that US position will not change Australian climate policy. And he's been very stringent on this issue of climate change, you know, literally being in denial for forever. In the United States, there's been the contribution from evangelical Christians, like regarding believing in that climate is not an issue, even if it happens, it's not matter. Is there any religious or cultural element in Australia regarding this sentiment?
It's a really good question. Upon religion, I'm not so sure. You may be aware that our Prime Minister is quite religious and goes to sort of church services for quite a sort of specific branch of religion. In Australia, there are a lot of, my understanding of a lot of religious people in Australia is that many of them do care quite deeply about climate change. So I don't think it's an easy question to ask. Culturally, we do have a problem, I believe. Culturally, there is, I think, a strong belief in most parts of the country that coal is good for the economy, and that there have been campaigns, as I've alluded to, that suggest that any action on climate change will be difficult economically, especially for power prices, but it also impinge our freedoms. There's been quite sort of almost hysterical comments by some politicians that action on climate change will bring us back to the Stone Ages and that sort of thing. So we are seeing more and more people care about climate change, especially after the bushfires, but it is a cultural problem.
I'd like to also make a question for Katta. It's not related to today's subject, but could you explain like how you become a lawyer in Australia? Like what kind of process you have to go through? Like is it like enough to just have an undergraduate degree, or do you have to? I think you need to work at a firm like at least a year.
Yeah. So you do have to do your bachelor degree and then your PLTs, which is your practical legal training. So that's with the law firm, or there's places set up where you can just do it there. And then you have to apply to be part of the bar. So you have to apply through the court system after you've done your practical legal training. But so it's after you've done your bachelor degree, then your practical legal training, and then apply through the court. Is that right, David?
That's right. Yeah, there's that's exactly right. So you need a degree, then you need further training and further experience.
Are both of you based in Melbourne or Sydney? I don't know.
I'm in Melbourne and David's in Sydney.
Oh, I see. Okay. I went to both places. Wonderful cities.
Yeah, nice.
I hope to visit sometime soon.
Yeah, I wonder if you ever can again.
Yeah, have you visited Korea?
No. Yeah.
I have. I loved it. I thought Seoul was a fascinating city. I really enjoyed it.
Yeah, I used to work at university with international students, and we had lots of people from Korea, and it was always, loved hearing about it.
Our university have I don't know. I've met people from University of Sydney Law School and also New South Wales and Melbourne. Came and talked. Maybe we can set up a sort of an international exchange arrangements so that our students can visit Australia and Australian students visit Korea too. So
definitely.
Are there any other questions from students who are listening now?
Well, I should have announced to my international environmental law students. I have quite a few international students there. It was a very interesting talk, but we recorded it, right? So that can be available for
yes
to watch.
I have another final question about the being lawyer in Australia. So is the system same to that of in the UK, in that there are barristers and solicitors, like the two different things, in that the barristers are like called by the court and doing real litigation, and solicitors are more like helping signing contracts like thing?
That's exactly right. So typically, if you want to be a barrister, you often will be a solicitor for a while, and then you'll sit essentially a bar exam and do a reader's course for 1 year, and then get called to the bar. And so the barristers will do most of the high level in court advocacy. So in Katta's case, for example, we have a retired federal court judge who is our Queen's Counsel, and we also have a junior counsel, so they're our barrister team, and we're the lawyers, and we do a lot of the research. We help get cases up and running. We do most of the liaising with clients. So there's certain amounts of freedom that we have that barristers don't, in terms of looking around for new cases. Barristers often get cases just brought to them.
My final question is to Katta. So I have to ask myself this thing, but what would you like to do in future? like maybe as a or barrister or a solicitor or as a lawyer in general, or pursuing this career?
That's a great question. Something I don't know the answer to completely, but I think being part of the case is really good to expose me to both being a solicitor and being a barrister. Looks like a lot of hard work. David often writes very, very well explained long documents. But I think being a solicitor and having the freedom to research and take on cases that you would like to take on is appealing to me. Maybe we'll try working or seeing how I go at a few environmental law firms or but still I like the area of law, but I'm not quite sure yet what I would do with it.
I think time is up, and I'd like to sum up our webinar session. Do you like to, both of you, like to make any final comments or to the audience?
You want to go, David?
Oh, look, just thank you so much for having us. Thank you for your interest. I actually had a few questions about your constitutional case, but maybe, if you have further information, you can send that to us. But thank you again.
Well,
thank you too. That is
Okay, thank you. Let's keep in touch. So okay.
Thanks for having us.
Professor Lee might invite you to his class in future. Maybe.
Yeah.
We get the international exchange worked out.
Okay, that's great. So we have a Center for Energy and Environmental Law. So we do offer very exciting events. So I would find a good opportunity to invite you all. Thank you.
Awesome.
We look forward to keeping in contact, and we really appreciate this opportunity and this exchange. So that would be excellent.
Sure.
Yeah, thanks for reaching out. It's great.
Yeah, thank you for arranging this, Myung-seo.